Good afternoon, and welcome to U of T Mississauga's three-part webinar series entitled, Do Later Life Healthcare Transitions Have to Be This Hard? This is our second session called The Sandwich Generation, Biting Off More Than They Can Chew. Before we begin, I'd like to share a bit about my background. My name is Shaliza Ibrahim, and I'm an assistant professor of numeracy here at UTM and also a proud UTM alumna. Here, I get to teach undergrad courses like Critical Thinking for STEM and the Science of Learning with the Institute for the Studies of University Pedagogy. I also collaborate and lead a few research projects focusing on critical pedagogy, place-based education, mathematical identities, and higher education in Caribbean contexts as well. So now, although this event takes place online, I'd like to a moment just to acknowledge this land on which the University of Toronto operates. We start by acknowledging that we are on the traditional territories of Treaty 13A, 14, 19 of the Mississaugas of the Credit First Nation and unceded territories. We are grateful to the Mississaugas of the Credit First Nation as the caretakers of this land and recognize the benefits we receive from this land. This land continues to be the home for First Nations, Inuit, and Métis peoples, and we thank them and other Indigenous people who have walked before us and share this land with us. Over 700 alumni friends have registered for today's webinar, which shows what an important topic this is to so many of us. Following the presentation, there will be a moderated question and answer period, and we encourage you to submit questions using the Q&A button at the bottom of your screen. If you're having technical difficulties, please just use the Q&A to send a message, and one of our staff will respond privately to you. All right, now I am delighted to introduce our presenter, Heather Snyder.
Hey, everybody.
Hello. As a teenager in Oakville, Heather was introduced to the world of elder care by the way of early employment in assisted living and helping family members through their palliative years in home. Champion Family Consulting was conceptually born in 2007, while professional opportunities in hospitality, adult education, sales, and leadership training were helping her build an arsenal of complementary skills. With the support of her family, the mother of two added nursing to her repertoire. With a compassionate, creative, and out-of-the-box approach to classically confounding challenges, Heather has an inimitable flair for clearing the fog surrounding later life transitions. And during our Q&A, Heather will be joined by her colleague, Anne Russell. So now, without further ado, welcome to our guest speaker, Heather Snyder.
Thank you so much, Shaliza. I am going to share my screen with you here now that I am a pro at this. Okay. Let me know if you can see that okay.
Looks great.
Awesome. Okie dokie. So yes, welcome to session 2. We're very excited to see that the numbers keep on growing, it's very exciting for us to get to reach this many of the alumni and hopefully answer as many questions as possible and keep on going into session 3. So we'll get started here. Shaliza already told you a bit about me. I'm also proud to be an active floor nurse at 3 hospices around Kitchener, Cambridge, and Guelph, and it certainly helps to keep my finger on the pulse of what families are going through and the challenges that they face. And Anne, our client and care coordinator, is poised and ready to head up our Q&A session in a little while, so definitely stay tuned for that. Similar to session 1, we're going to attempt to whip through a lot of important content here today while weaving in personal and professional anecdotes to help bring the material to life. This subject matter has the potential to be a wee bit dry, so we'll try to pizzazz it up as best we can. And as we introduce and discuss buzzwords and industry lingo, I will always define these terms as I go, which will inevitably be redundant for some listeners, so bear with me. But some concepts will likely be friendly reminders for some who use and encounter these roles and concepts on a regular basis. But I'm going to present the info assuming that we're all starting from a place of new learning. So what we're talking about here today, the burden or the burdens on the sandwich generation. So sandwich generation meaning adults who are caring for both their own children and their aging parents concurrently. We'll talk about substitute decision makers, so SDMs, and the hierarchy, as is outlined in the Healthcare Consent Act of '96. We'll talk about powers of attorney, both personal care and property. We don't spend as much time on property. Our focus is really going to be more heavily on the personal care side of it. And then touch a little bit on estate trustees, executors, and how this is different from the POA. And then also we want to get into briefly the DNR, do not resuscitate order, MAID, medical assistance in dying, and palliative sedation therapy. You could fill an entire hour just talking about these three concepts alone, but we do feel it's important to touch on them and define where and when they can be utilized and explored. And then, of course, initiating and navigating difficult family discussions about all of the above. So, go. So being sandwiched between two groups of loved ones, I really liked that. I liked that graphic, who have varying degrees of needs, wants, and timelines can be very stressful and can feel a bit like running a marathon with no finish line. In fact, chronic stress is one of the most reported symptoms of being in this role, as those in the sandwich generation have reported that they're constantly on and needed at any given moment by a loved one or several loved ones at once. It acts as something of a vicious cycle that feeds and builds on itself and can lead to burnout if proactive steps aren't taken. So, I mean, sandwich generation is still sort of a new-ish term. We don't hear it everywhere we go, but it's certainly becoming more popular. A lot of factors got us to this place, main culprits being increasing lifespans. We're living longer on average. We're having children at an older age. And there's more societal acceptance for adult children to live at home well into their 20s and beyond for various reasons, financing being a big one. And depending on the family, the geographic area, and various cultural factors, the idea of taking care of your parents and your kids concurrently is likely not a new earth-shattering concept. However, you'd be surprised at the number of ongoing challenges that pop up along the way when trying to juggle the health and happiness of many loved ones at once, including your own needs and your own healthcare status. One of the biggest challenges we hear about from our clients is having to ride the very thin line of parenting your parents while maintaining their respect, dignity, and autonomy, which can be kind of a tricky, a tricky balance when it comes to communication and sort of how deeply we get into things with our own parents when they still feel like they're in charge, but things are changing. As health deteriorates in the elder part of the sandwich, care needs heighten, which means more time, more money, perhaps time away from work for those in the middle of said sandwich. Roles are spread more thinly, and we can find ourselves in that predicament of feeling like we're not really doing any of our roles to the best of our ability. And I'm sure a lot of people on here can do a big head nod to that one. It's in this stage of life where advanced care planning becomes so important. I'm just going to read a quick blurb from the Speak Up Ontario Advanced Care Planning Workbook. So that's an actual physical workbook that I have, but I've linked it at the end of this presentation for you as well, so that you can access it anytime. It says, life can change in an instant. Imagine you've been in a serious car accident. You've lost the ability to speak for yourself or direct your care. You do not recognize your family or friends. Do you know who would make health and personal care decisions for you? Your widowed mom has had a stroke and is unable to speak for herself. Do you know what kind of care she would have wanted if able to speak for herself? Who would be your mother's substitute decision maker? Who would make health and personal care decisions on her behalf? You? Your siblings? Your health and personal care circumstances can change quickly and without warning. None of us know what tomorrow will bring. We cannot always predict if or when we will need to rely on others to make health or personal care decisions for us, or when we will be called on to make these decisions for a family member. So I liked how direct that booklet puts it, where it really kind of brings into the forefront. We really don't know what's happening, but we want to try to be as prepared as possible. So building again on session 1 and our proactivity, let's talk about how we can do that. So that brings us to this very, very common term, a substitute decision maker. This is a designated person authorized to make decisions on behalf of a patient who's unable to do so for themselves. So this could be choices about healthcare, medical treatments, nutrition, living arrangements, even hygiene, and in a lot of cases, safety. And under the Healthcare Consent Act of '96 that I mentioned earlier, a substitute decision maker really must be capable of making the decision, so understanding the information that's being laid out, and be able to foresee the reasonable consequences of that potential decision. They must be 16 years of age or older, available to make the decision, and not prohibited by court order or separation to do so. So there are 2 points here on this slide that pop out to me more than the others based on some of the questions that came in, and that's capable and available. In session 1, we talked about steps that can be taken to be a strong advocate, including starting a care journal to document info from appointments, facility tours, difficult conversations, that kind of thing. And if you recall Anne saying from the Q&A, if you care, you got to be there, meaning that it's very difficult to be an effective SDM for someone if you live far away from that person. This is partially why there's such a great role strain on caregivers and advocates, because it can require you to put a lot of other things on hold when crisis strikes. This can get even more challenging if there is no official SDM named. So if you have an elderly parent who is living in Ontario, but you live overseas, or you live, your parents are in Ontario, you're in BC, it can be a really big challenge if you are sort of the go-to. So kind of time to start thinking about who might also be a good go-to who's more local. Really the most straightforward path in all of this is to identify a substitute decision maker, or more than one potentially, and have that decision maker sign a legal document called a power of attorney for personal care. So you can see that here on the hierarchy that I've pasted on the slide. If a patient does not select someone to support this task, or does not actually grant someone power of attorney, the law has outlined this list of people who can act as their substitute decision makers. So in the example I just read to you about the widow who's had a stroke and is unable to speak for herself, we would take a look at the hierarchy here, and from top to bottom, assuming in her case that there's no court-appointed guardian in place at the very top there in the yellow section, we would then want to know if mom has already filled out the paperwork for a personal care power of attorney. We find that she had old paperwork that named her spouse as the POA, but he has passed away. So we would keep working our way down the hierarchy. It's unlikely in this family that a rep from the Consent and Capacity Board has been appointed. So we would move into the green section of that, the automatic family member SDM. So you can see spouse or partner, parents or children. As we know, her spouse is gone, so we land on the parents or children line. In this case, her kids are, in the case, if her kids were incapable or unavailable, then it would keep moving on down. So knowing that the attorney for personal care trumps the spouse, partner, the kids and the parents, we really need to take a look at that. So within the power of attorney realm, we have 2 different types. The personal care power of attorney would help make decisions on things like consenting to tests, surgery procedures, medical care, starting or refusing treatment or withdrawing life-prolonging measures like life support, admission or discharge from a medical facility, moving into or receiving care in a long-term care home. So all of these things that have to do with healthcare planning and next steps in a crisis where you can't speak for yourself. Whereas an attorney for property can make decisions about your financial affairs. So that would be things like paying your bills, collecting money owed to you, maintaining or selling your house, really more on that property and financial side of life. There actually was just a little known fact that when you do appoint someone to be your attorney for property, they can actually start making decisions about your financial affairs immediately unless you state otherwise. So that's just something, it's not terribly relevant to our content today, but just something to be aware of, that if you are coming out of this and you're getting all of your POA documents put together, a property POA needs to be stated that it's only in the case that you are incapable of making decisions, and that needs to be stated specifically. Otherwise, they can be involved as soon as it's signed. So truly, I mean, this POA, whether it's one type or the other, this person becomes your voice. So we had a really great question come in after the last session about loved ones who live in a retirement facility, but they're unable to communicate for themselves. So the resident within the facility is unable to communicate, whether that's because of some type of aphasia or language barrier, but they require their SDM to be their voice within that retirement home. The question was whether or not there could be an adjunct to the resident council within these facilities, which would be sort of an SDM council to give a voice to those residents who are unable to participate themselves. I spoke to a couple of folks in the larger retirement home brands, and they said it was actually a really good idea, that they hadn't heard of it really, that there was no official SDM council in place in retirement living that they knew of, but a really great idea that could be brought to the general manager of that facility to say, you know, we really want to become involved and help this resident or this group of residents have a voice. And they're always, the retirement homes and really any facilities are always looking for ways to provide better, more personalized care. So I just thought that was a really neat question, because I'd never heard it before. So that's a great example of an SDM stepping up to the plate as a strong advocate. These questions that I've posted here on the slide, just a few of the ones that we hear all the time. When should I appoint my POAs? Now, tomorrow, yesterday would be good. Really, as soon as possible would be the most proactive answer. Certainly after there's been a death or significant loss of someone who you may have named officially or unofficially. I mean, if you have gone through a divorce, there's been a death or a falling out, definitely a really good idea to revisit those documents and make sure that the person that you have named is who you want to speak for you in a time of crisis. Do I need to go through a lawyer? The simple answer here is no, you don't have to. I've linked at the end of the presentation to a free POA booklet download. But in speaking with my own lawyer recently, I mean, even he confirmed that it's not a must to go through them. But the more complicated your situation, the more peace of mind and guidance you will receive by going the lawyer route. So I likened it to doing your taxes. If everything is pretty straightforward, you can get yourself that software and file your own taxes. If you run a small business or work in commission sales or have multiple employers, you might want to take that to an accountant. It's really no different. Can I name more than one person for one or both types of POA? Absolutely, yes. Which kind of connects us to these last two questions as well. Who should I choose? And what if my choice causes family drama? Well, in hospice, we often have families where 2 or 3 adult kids have been named as personal care power of attorney. Sometimes it works beautifully. More often than I care to admit, it does not. The bottom line when asking yourself, who should I choose, is that this person becomes your voice while you are still alive, but incapable of being your own voice, and usually in quite dire situations. So who knows you best? Who knows the real you, and who understands the role of the power of attorney best, and knows that it's not about what they want, or what they would do in a similar case. That's a really important differentiator. One of the key takeaways here is that with POA for personal care, you must be able to put your hands on this document quickly and at a moment's notice. So whether you're doing this through a lawyer or not, you would usually make sure that the grantor has a copy. So whoever's granting the power of attorney to someone has a copy, as well as any and all of the POAs who have been named, and the lawyer, if there is one, helping you with it. But the key here is make sure you know where it is and you can put your hands on it, because you will need to show that to whatever healthcare setting is requiring it of you to make those decisions. Which brings us to jointly versus jointly and severally. So within the POA world, this is only relevant if more than one person is being named as power of attorney. Let's take the example then of the mom who's had a stroke that we talked about earlier. She has 2 daughters. Let's say she filled out personal care POA paperwork, naming both of her daughters as such. She has named them jointly. So in this scenario, both daughters would need to agree upon and sign off on all major healthcare decisions unanimously. This also means that if you think back to what qualifies someone to be an SDM, that both daughters must be capable and available. If one daughter lives close to mom, but the other lives overseas, this could get more challenging and potentially could affect time-sensitive next steps for mom if we're still waiting on the sign-off from the sister who's far away. Jointly and severally means that each person is equally responsible for the POA tasks, both individually and collectively. In our example, if mom has named her daughters as personal care POA jointly and severally, then the daughter who is local may sign off on healthcare decisions while her sister is traveling to get there or is otherwise unreachable. The key to granting power of attorney for personal care is making sure that everything can function as efficiently as possible if that POA needs to be enacted. So efficiently, know where that book is, have somebody who can make the decisions and who's available and capable to do so. Too often I've seen families where more than one person is named in an attempt to not hurt feelings or come across as though you're playing favorites. We've even had clients where they've named 2 adult children jointly, but these children hadn't spoken to each other in over a decade. The parents' hope was that this would sort of force them to come together on a common goal or project. But let me say it again. The key is to plan for efficiency and decisions that can be made as closely to your own, to what you would do. You can imagine what the outcome would be with these 2 estranged siblings attempting to make a big decision for mom or dad. It's usually not good for anyone involved. So I put down here on the slide, people often try to people please when granting POA to loved ones. But if you take anything away from today, please try to give that a bit of a backseat and really keep in mind what this is being used for, and in the situation where you really need to have clarity and efficiency. So dissimilar to the POA SDM hierarchy, the estate trustee and executor, you'd be surprised how many times that we have a lot of clients and a lot of people in the community who get confused about the role of the executor versus the POA. The executor is really only enacted once somebody has passed away. It's only after death. The POA is only while living. So that's a huge differentiator right there. An executor, sometimes also known as an estate trustee, is a person who manages the estate of a deceased person. In Ontario, they're responsible for carrying out the wishes that are outlined in the will, or in accordance with provincial law. Now, we don't spend a whole lot of time here, as this truly goes beyond our professional scope as nurses, but the same or similar questions can be examined with regard to who you name and appoint into these roles. Because a lot of times if people are putting together POA documents, they're likely going to be looking at doing a will and testament at the same time. A lot of the same factors should be considered, with trust being at the top of the list. In this case, also having someone who is well connected within the immediate and extended family can be helpful, because as executor, you're going to have your hand at a lot of different areas of the family that maybe you don't normally. And then, do I need to go through a lawyer? I'd say that's a big yes on this one. So where it's a little bit less necessary with the POA, we always recommend our clients do go through a lawyer for any kind of will, testament, estate trustee, and executor naming. So we'll just take a look at all the different pieces as a whole. A living will in Ontario. So you see, we've got our patient client up here at the top. If you put together something like a living will or a just-in-case file, which we will talk about in more detail later, this is a document that expresses your wishes for care, medical treatment, where you want to live if you're no longer able to communicate. This can be written directly into your POA documents, and when done so more officially, we usually see them called advanced directives. But essentially, it's kind of all advanced directives, and living will is kind of all the same thing. It's not a legally binding set of information, but it can, and in a lot of cases maybe should be written into the POA documents, just so that you can state what your wishes would be regarding life support, surgeries, other major decisions. It's very individual, but the more information you include, the less guesswork there is for your POA. You'll see down at the bottom of the graphic the DNR order. I want to make sure we put a little bit of clarity to this, as it still seems to be misconstrued by patients, families, and even some healthcare workers. So we'll just give you a little look-see here. Okay. I know there's a lot of writing on this slide. I don't usually do that. So bear with me here. The DNR order, do not resuscitate order, it's a legal document that instructs medical professionals not to perform cardiopulmonary resuscitation, so CPR, if a patient's heart or breathing stops. A DNR order is usually created after a patient, their loved ones, or their legal decision maker have discussed the risks and benefits of CPR. And people with terminal illnesses or other serious medical conditions often choose to have a DNR order put in place. And we always think of it as, once you've reached that level where maybe you do have a terminal illness, or the risks of CPR have been deemed to exceed the benefits, we think of this as letting nature take its course. So that's kind of, just as a visual, that's sort of how we think of it. Again, this can be written into the personal care POA. It does not, though, and this is a big area of confusion, it does not negate investigative testing and other treatments. So putting a DNR in place does not mean that you can no longer receive treatments for that illness, or continue to do testing to see if there are other treatments that are available, that kind of thing. If you do have one, though, it usually is, for the most part, it's enacted by first responders. So best place for this is either right on your fridge, magnetized to your fridge. If you have that on top of the fridge, that's usually where first responders, firefighters, and paramedics will go to look for it first. And the DNR order is about CPR only, so not medications, food, or fluid intake. MAID, so medical assistance in dying. We do get a lot of questions about MAID, and it's still fairly new. So this has only been in Ontario since 2016. So there's constant change and constant learning still taking place. But essentially, this is the administering by a physician or nurse practitioner of a substance to a person at their request that causes their death, or the prescribing and providing of something that the person can self-administer, which in doing so will cause their death. So to receive MAID, a person there's criteria that you have to meet. You have to be 18 years old, be eligible for health insurance, capable of making healthcare decisions, have a grievous and irremediable medical condition. That's a big one. And have made a voluntary request for MAID to get started into the system. So it is a two-step approval process with doctors who are specifically tasked with this. And of course, the patient must have decision-making capacity for both the steps. So we've seen, again, in hospice, we've seen someone who desperately wanted to receive MAID, and they made it through the first step, but their health and cognitive abilities had deteriorated so much between step 1 and 2 that they were not capable of passing step 2. And it's very sad when when someone's plan or wish really can't be carried out. They have made some changes to it over the last couple of years with regard to the date. So within the two-step process, you can actually sort of put off choosing the date that MAID is administered, which gives a little bit more flexibility. But you really must prove a life-limiting illness, but not necessarily, the MAID itself is not necessarily based on trying to solve a current or present intractable symptom. So it's a little bit different from palliative sedation therapy, which I'll tell you about right now. So I'm not sure how many of you will have run into palliative sedation therapy or PST. This is different from MAID because it's the intentional and continuous induction of a reduced level of consciousness, so of sedation, in order to relieve a refractory symptom or symptoms in a patient who is at the end of life. The intent is to relieve suffering, but not to hasten death. So big difference there from MAID to PST. An intractable symptom essentially is something that is difficult to treat or manage, or doesn't respond to treatment. So pain is usually a big one here. It's probably the most common, as certain medical conditions and disease processes can lead to chronic, severe pain that no longer responds to even the strongest medications or interventions. So important to know sort of what makes you eligible for this, and it must be ordered by the physician and only when all criteria are met. So it also can't be initiated without the consent of the person or the SDM. We often see that the SDM is in the role of consenting for palliative sedation therapy because we are trying to help somebody who is so far into their disease process that they're not in a decision-making capacity themselves. Now, one of the hospices I work at does allow MAID to take place in-house. The other two one does not, where the other two do. And it's still very much evolving and being developed in Ontario and has a lot of tricky red tape for obvious reasons. So that's also something if that's something that you've talked about with a loved one, or that is on someone's mind, just important to know that it often will happen at home, but if you are in a facility, really important to make sure that that facility allows it to take place. Otherwise, you might have to make some plans or provisions for a move in order for the MAID to be administered. So before I get to the conversation starters, I'm just going to kind of give you the key takeaways again. POA is a type of substitute decision maker. So when grantor is alive, but incapable of making decisions for themselves. Whereas the estate trustee or executor, that is when someone has passed. Again, probably telling you something you already know, but we've had enough questions about it. I'm just going to put it out there again. Clarity and pre-planning is a must with emphasis on efficiency. So again, have that journal of notes that you're taking when you talk to your loved ones, have notes that you're taking at appointments. Take notes and keep them anywhere. It could be electronic, it could be a folder, it could be anything. And write down and store important information in a place that is accessible at a moment's notice. So that's where, our electronics are really, really helpful. If you can keep a notepad in your phone, most of us always have our phone on us. Just be able to find it is the main thing. And then manufacture the opportunity for tough conversations before you think you need to. And by manufacture the opportunity, I truly mean it's not going to happen organically at the right time. It might, that's very, very rare, but it might be up to you to kind of guide that and make it happen. So on the next slide here, again, I know there's a lot of writing, but I've given you some potential conversation starters. And this is your mission between now and session 3, should you choose to accept it. We just need the Mission Impossible music playing. If you're seeing your family members, and I know some of them maybe sound a little bit kitschy. So we've got, I've been taking a course at the university about how to plan for the future and need to interview someone as homework before the next session in January. Could you please help me with this? So put it on us. Tell them that we made you do it. And I know no one likes to talk about this. It's a difficult topic, but Heather and Ann, they're on us about it, and we need to get questions and things back for session 3. Blame us. I've been tasked with creating a just in case file for myself and didn't realize how many details are needed. Have you made one of these? So kind of opening up a conversation about what types of planning they might have in place already. Do they have a living will? Do they have anything stored in a place where someone could find it if they were to fall into a health crisis all of a sudden? I'm working on a living will and have a couple ideas I think might sound weird. Can I read it to you? So again, it's really, we kind of touched on it in the last session, but it's about sort of changing the focus from, oh my gosh, I think you're going to die soon, so we really got to get this stuff down on paper. We really need to get this figured out. It really kind of changes the whole direction and vibe of the conversation if you put it on you. Like Anne said in the last one, if you tell a story about somebody, oh, somebody just went through this, can we talk about it? It really, kind of upset me. What are your thoughts? Really divert that attention somewhere else, and it can be a really good way to get into it. I've also got here, could I help you file and organize your documents? It can go a lot faster with 2 sets of eyes. I know my mom and I have done this over a glass of wine, and figure out where everything is, and you can kind of make it sort of a fun project, maybe put some music on. And then I also have here, watch a movie that touches on aging, dementia, etc., and ask if they've seen it. You could say something like, it really bothered me when the family seemed so lost in this situation. There's lots and lots of movies out there who are that really deeply go into these topics. Still Alice, Away from Her, a couple of good ones. Even The Notebook. I hope a lot of people on here have seen The Notebook. I mean, that touches in the end on the challenges of moving someone out of their own home who has a progressive dementia, which we've also had questions about from registrants in this webinar series. And it's a very tricky question of how, I know we talked about how do we broach the subject of making a move to parents who don't feel they're ready. Well, that's one thing. Broaching that same question with someone who has a dementia is a totally different thing. So, in The Notebook, they talk about how he moved into this place with her because she's his home, and that's why he's there. And he reads her this book and the story of their life and tries to bring her back. And it is true that with some dementias, there are those moments of lucidity. The key with making a change for somebody in that scenario is to really try to link up the person's personality to the correct type of care or the correct type of setting. So whether that's a facility, an altered home, something that really kind of touches on the core of who that person has always been. So if that's an outdoor person, an industrious carpenter type person, someone who loves gardening, sewing, knitting, whatever those core longtime passions are, if you can try to find a way to connect those to going on tours of places, going to a lot of nursing homes will have they'll have like happy hour on Fridays where you kind of go in and get a little bit of a soft entry, soft introduction to the place, but then you go home again and it doesn't become this big scary thing, but you sort of ease into it. And then really important is striking when that person might be open to it in a more lucid moment. So kind of getting all those ducks in a row so that if you're finding that there's a little bit more of a accepting period of time, whether that's a day or a couple of days, being able to strike when the iron is hot is very, very important. Because you'll have all kinds, there's so much variation within dementia, it can be very difficult. So, and with that being said, I mean, the personal care power of attorney is all that you need to make that move until the time of admission, at which point you do need to know who the property power of attorney is to actually finance the move. So also just a little food for thought. Looking ahead to session 3, before we get into the resources and the Q&A, session 3, we will be digging much more deeply into the family dynamics piece. So supporting family members who are navigating complex dynamics, mental health challenges, balancing responsibilities to minimize disrupting daily life and those relationships. And then we also will go into some empathetic techniques such as recognizing subtle yet important cues. So there are so many times that we talk to clients and we're told their story and their story of what's going on. And just from an objective sort of neutral standpoint, we can say, well, what you told us, it sounds like it could be that their hearing has gone maybe a little bit. They may not be actually hearing what you're saying and therefore processing. It may not actually be a dementia coming on, like that, types of things like that, that we as a neutral party can kind of help see in a different light. And then, of course, asking the right questions at the right time and of the right people. Anne herself is an absolute expert at that, at finding the right people in the healthcare team or in the facility who can get things done. And then strategies for diffusing difficult emotional situations as well. So that'll be during session 3 on January 21st. And please, please, please do send, I know it's hard to get it through all the questions here. Please do send questions in between to the admin email here. And then we can incorporate as much as we can into that. And then I've got your resources here, the Speak Up Ontario Advanced Care Planning, the POA booklet, and then the just in case creation. So we're going to talk a little bit about it in Q&A, but I've also included an article here, which I know looks not all that legible, but I promise it is in certain views. A little bit of an article here. It's kind of more of an anecdotal telling of what the just in case file is and how it's utilized, but really kind of a quick, easy read and speaks to the importance of having one. So I think that's all I have, so we can get right into Q&A and go from there. So let me stop my screen share here. Oh, in theory. Sorry, guys. There we go.
Thank you. Thank you so much, Heather. That was an absolutely enlightening session. I can confidently identify as a sandwich parent now, after hearing what you've shared and sort of recognizing all of these challenges and the beauty really of aging and living through it with your parents. So to our audience, if you have any questions, please use that Q&A button at the bottom of your screen and we'll get to as many as we can. I would like to now welcome Anne Russell, who will join us for the Q&A. Great. Thank you so much. As a registered, wonderful. As a registered nurse in her early 20s and graduate of the public health nursing certificate at University of Toronto, Anne started out at the Red Cross Outpost Hospital in Minden before finding her favorite role, which is discharge planner at Oakville Trafalgar Memorial Hospital and Trillium Health Partners for 30 plus years. She has gone on to roles as nursing supervisor and hospice RN before becoming Champion Family Consulting's client and care coordinator. So, welcome, Anne.
Thank you very much.
All right, well, let's get into our first question. And we had a few pre submitted ones. So, maybe I'll start with that one first. The first one is, what do I need to know and find out ahead of time if I'm named as the POA and or estate trustee?
That's huge. And I think Heather has certainly given you a lot of information about what to do. But I wanted to share with you that a number of years ago that I came across that particular article that Heather has at the bottom of the slides and is going to share with you. And I found it in a retirement magazine, but it made such an impact because, and I kept it, and I've actually shared it with many, many people over 15 years. That's when I found it. But it was the most heartfelt, comprehensive, personal story of what can happen. And it was written by a woman whose husband died suddenly. And she had a child still at home. And of course, she was grief stricken, but she found in the filing cabinet a binder, and that was done up by her husband. And it was called his just in case file. And that's where our knowledge came from. And it was such a great idea because she said it was the most wonderful gift he could ever have left her with. And in that binder, it didn't include actual documents. It doesn't have to, but it does include where to find things. So where to find those documents. Is there any insurance? Where is the safety deposit key? What are the passwords nowadays? What are the passwords? And who does he want you to contact? You know, what are all the friends and people? It might have a list and addresses of who to contact. What are his wishes and advance directives? And through that, she journeyed through, and it's a lot to do when something like that happens, but she found everything in there that she could ever have needed. And it was really neat because the very last paragraph, if you read through this article, and she said, the just in case file, a homely 3-inch binder, was a husband and father's practical last gift, and it still makes me feel cherished. Perhaps his idea will help you and your loved ones. So that's why we included it. And it always breaks me up. It's just so thoughtful and so helpful. So I encourage you to read it and do that.
Even things
Thank
like
you.
keys to a safe in the house, banking information, all of those things that I always encourage people to sort of say along the same lines as that journal that you're keeping full of information for everything along the way. Do a little bit of a self-reflection on your own life and think about, as you're going along your day, or probably even better would be your week, as you have to access things that have any kind of password or any kind of roadblock that you need to get through that you do know how to get through. Jot it down. Like, oh yeah, my ATM card, my Netflix account, my whatever it is. And
Mhm.
and that can really be a helpful start to a list of things to ask for from the person that you may be the SDM or the POA for in the future or now.
Thank you. Actually, there's another question that comes in, and it's one that might not be in that just in case file. The question was, can a POA request a DNR? So I do not resuscitate.
Yes, if the person, and certainly it can be a request via, if the person is competent, it's a discussion that has to be done with the doctor generally, and the doctor sort of gives you that form to fill out. If the person is incompetent, but hopefully the POA knows that that was their wish, and I've been through that myself. Together we were at the doctor's, and this person doesn't really have the whole comprehension, but I know from years gone by that is their wish. So with the doctor's involvement, yes, we did do a DNR because that absolutely would be his wish. So yes, it takes good support and good knowledge to make this decision, but yes, you can.
And good background information on how that POA or that SDM can make it clear to the doc, here's why I'm requesting it, and here's what I know from the patient themselves. And you know, we know the costs and the benefits of CPR at this point, and really kind of goes back to session 1 a little bit again with regard to factual objectivity and having all of those things ready and in your arsenal for information's sake when you're in those meetings, just to say here, to lay it all out and have all the information present so that the doctor can feel confident in it as well.
Heather, you mentioned SDM. When a POA is in place, does one need a SDM?
Well, the POA in that case is the SDM, and that was, and that's why the interchangeable language can be kind of tricky, because you know that that graphic that we had, that the hierarchy of SDMs, technically the power of attorney exists within that. So like this graphic here, the power of attorney is the second one on the SDM hierarchy. So I use them kind of interchangeably, but no, if there is a POA in place, that POA is the SDM, if that answers the question.
Yeah, I hope, I think it does. And I appreciate that clarification for our alumna. Another question was, what provisions or plans can be made if there is an adult dependent living with a loved one who's being relocated to a care facility?
Yeah, that really is a difficult situation. And usually it refers to someone like a child who's now an adult, maybe anywhere a young adult into middle aged. Perhaps that person has cerebral palsy or MS or autism or Down syndrome, or somebody who's young that's had a stroke, often looked after by, you know, the parents and in the home. And you really hope that over those years they've made some provisions or looked into see what is available out there, but really prefers to keep their child or this person at home as long as possible. I did have a patient a number of years ago, and the father had died a number of years before, but I was a VON nurse going in to see this family, and this fellow was in his early 30s at this point. But the really wonderful thing was that this family had been the driving force to actually set up a home for handicapped people. And I'm going to call this fellow John, and he was cognitively brilliant, really, but he just physically could not look after himself. And out of that driving force was born Deborah's home, which is actually in Milton. And from that, there was a corporation formed, and now it's known as Independent Living Halton. So just give you an idea, this Deborah's home is in Milton. The mother actually died unexpectedly at fairly, well, I think she was in her late 50s, early 60s, which is young. And Deborah's home was just having been created. And that's the daughter came home, looked after John until he found a place there and lived there a number of years. But it gives you an idea of how necessary it is to look and see what's in your own area and be proactive about putting your name on waiting lists for something like that. There are outreach personal care programs that do exist. Community Living has a number of outreach people as well as houses, but their waiting lists are very long, so you need to do it proactively. And then, of course, Ontario Health at Home also has, I've just chatted with a case manager that they will take applications for long-term care for younger people if they meet the criteria and the need. So they could also be admitted to a long-term care facility if a crisis happened, or if the need, or while waiting for something else.
Those early conversations are so important. So you know, have clarity on what what they would like and what's going to happen in those situations. We have a question that's quite specific, and maybe it's a good one after what you just shared. So I'll speak as the alumna has asked this question. So we have our POAs done for my mother. I'm her financial, my aunt is her health. But her healthcare providers are still depending on her to relay information and make decisions on her own, and they don't keep us in the loop. How do we get her health team to allow us to support her? Her cognitive ability has been greatly declined, and she used to be able to advocate for herself, so they don't understand that she isn't capable anymore. Is the best route to get a cognitive assessment?
I would say that would be a very good place to start. And for who the POA is really needs to open up that communication and let whoever it is know that they absolutely have to be kept in the loop, because that was the decision that was made before mom became incapable. But a good place to start would be the doctor, and then see if there's people coming to the home. If long-term care, if Ontario Health at Home, they also do capacity, but only at the time of doing capacity assessments in order to do long-term care papers.
I think that's probably
it-
helpful.
It's all about communication among the team or the family members. It's absolutely crucial, especially at this stage.
I'd like
Yeah,
to
'cause
think
if
that the health team. Sorry,
sorry,
go ahead, Heather, please.
the aunt is the health, is the personal care power of attorney then, and not the financial. The daughter is the financial and the aunt is the personal care. Is that what I understand?
Yes. Yeah.
Yeah. Yeah, I agree with Anne. I think cognitive assessment for sure. And again, sort of coming to the table with proof of what's going on, and some anecdotes around what is concerning the family about her ability to make decisions for herself. Because if they're still relying on the client or patient in question to do that, they are not with her all the time. So they wouldn't, again, it goes back to the whole they're not mind readers thing. So any information that you can kind of give anecdotally that says, here's why we think this and here's why we're worried, just helps you to be that stronger advocate as well.
Mhm. We're running out of time, but we have one last question that I'll pose. Could you explain life-limiting illness in MAID in more detail, and what would be some examples?
I mean, usually with MAID, you'd be looking at something that historically has a prognosis. I don't know if there's actually a specific, it's not as specific a prognosis, like 3 months or less, but usually it's something that historically has a predictable path that it takes. Things like ALS and Huntington's and certain types of really aggressive cancers that are pretty true to form when it comes to the trajectory that they take and the sort of difficulty in the end days. That's usually what people are looking at for MAID, where they want to try to maximize the time that they have that is more or less healthy and enjoyable, and they have that quality of life, but then have the option to then not live through that portion of the disease process that is the absolute antithesis of quality of life. So can you add to that, Anne? Is there something I'm missing on
I think what I think of it as, and have explained it to people, is that where there's no hope of recovery from whatever illness it is. I have a friend who has COPD, so chronic lung condition, and heart failure, and then she broke her hip, and she's still hoping, she's going to actually have this hip repaired and hoping for more mobility and kind of holding her own. But she went through all the steps of MAID because she wanted to have that option, and it made her feel much more at peace, just that it's in place. But I think for a lot of people, some of those diagnoses you see where it's going, and they are usually progressive, chronic, and then progressive. And it's a very, for some people, it's just very comforting to have that in place. but as Heather said earlier, you don't need a date to set it up. But it's usually for those kind of illnesses where there's no hope of recovery.
Thank you for that. Yeah, I mean, it's the first time people are going through the illness, the first time people are aging through these
Yeah.
moments. So they're
Mhm.
navigating it for the first time, along with their loved ones surrounding them. It really appears that we have all the time for questions this afternoon. So, to our audience, we received a lot of questions today, and we apologize if we were not able to get to yours. We are looking forward to the third part of this series on January 21st, and we encourage everyone to submit questions then that we weren't able to get to during this session in advance of that session 3. And so, on behalf of U of T Mississauga, I'd like to thank Heather and Anne for their time and thoughtful responses to the questions from our alumni audience.
Thank you guys so much. We really appreciate being here and being able to talk with you.
Thank
Thanks.
you.
Beautiful. Everyone who registered for today's event will receive a link to the recording in their inboxes in the coming days. Along with the recording, you will have an option to take an online post-event survey, and we do hope that you will take a couple of minutes to complete it, as your feedback is helpful for planning future events. And if you enjoyed today's webinar, be sure to check out the upcoming events listings and more on the UTM alumni webpage, and it will pop up there for you. So thank you again for joining us. We look forward to hosting you again at another U of T webinar.